Hello, everyone. I am so excited for today. So many of you have been following me through my journey with my mom's case, which is based in, of course, Klamath County, Oregon. I'm in a unique position where I've been in courtrooms before, right? As a reporter, it's a very different view when you're a crime victim, and it hasn't been the easiest to navigate. I'm not from Oregon, and the criminal justice system is complicated. So I thought it would be best for you, for me, for all of us to be able to talk to a prosecutor in Oregon, in Klamath Falls, and we are going to be doing that today. I'm going to be bringing on Cole Chase. A lot of you recognize that name because he is a prosecutor on my mom's case, but I want to be very clear, crystal clear, actually, that we are not going to be discussing my mom's case whatsoever, nor any open case in Klamath. Today is about getting a better understanding of the criminal justice system in totality. Let's go. It's going to be fun. Yes, Mr. Chase, welcome.
Hi, I'm Cole Chase. I'm the Senior Deputy District Attorney here at the Klamath County District Attorney's Office.
Thank you for joining me. I have a little introduction. Are you ready?
Sure.
All right, here we go. You are the Senior Deputy District Attorney at the Klamath County District Attorney's Office. You have practiced law since 2004 with over 17 years at the Klamath County DA's office, where you started as an intern. Besides your duties as senior DDA, you oversee all grand jury proceedings. You are the chair of three separate multidisciplinary teams, including sex abuse, elder abuse, and domestic violence. Your caseload usually consists of serious person crimes, complex property crimes, and animal abuse cases. You handle all juvenile sex offender cases in Klamath County. So far this year, you have had 8 trials resulting in 6 convictions, and you are currently running for the circuit court judge position too.
That's
I do.
correct. Yep.
So, in preparing for this interview, you had said something, and it's just kind of been marinating with me the last couple of days. I'm going to quote you. You said, quote, prosecution is a process, not a result. Tell me what you meant by that.
Well, so often people think, oh, he prosecuted that case. That means that he had the case, did it, it was done. It's actually the prosecution is a process. It includes investigation and it's iterative. It goes back and forth. So as we start a case comes to us one of two ways. It can either be, well, a case starts one of two ways. Typically, law enforcement is either out on patrol, they observe a crime and start an investigation, or they're dispatched and start an investigation. So, in a case where, like our multi-agency drug team is investigating cases all the time. They get information that an individual may be engaged in criminal behavior involving controlled substances. And so they'll start looking into those people. They'll talk to snitches. They'll set up surveillance on a house. They'll see if people can do buys into that house. And then that's an ongoing investigation. After that investigation has gotten to the point where they believe that they can refer it to charges, then they send a report to our office. And for our office, that's when a case starts. A case starts when we get a report. We can't do anything. We don't have our own investigative wing. We have 3 partners well, primarily 3 partners. In fact, some of our smaller communities also have law enforcement agencies, and we do get reports from them. But primarily, Oregon State Police, Klamath Falls Police Department, and the Klamath County Sheriff's Office are our 3 main law enforcement agencies, and the vast majority of our cases come from them. So they will get a report or do an investigation and send us a report.
As a prosecutor, who do you represent? Do you represent the state, the people, or crime victims? Which three?
So it's a balance. Officially, we represent the state. Our effort is to seek justice and to make sure that the citizens of the state of Oregon are protected, and that people who violate the laws of the state of Oregon are held accountable for that. That's the primary responsibility. Now, as a result of that, that means that we come into contact with victims. And as you're aware, victims under Oregon law have specific delineated rights under the Oregon Victims' Rights Act. And also, they just have rights that any decent person would think they would have, which is we're going to communicate with you in a timely fashion. And if you choose to be involved, because not everyone chooses to be involved in their case, if you choose to be involved, we're going to communicate with you and keep you apprised as the case moves along. But there are certainly times when victims, they don't want to have any involvement in their case.
You have seen that where victims kind of wanted to take
That is far more common. That is actually the most, yeah, that is the most common. It's like, okay, well, just let me know about dates. I don't need to show up for appearances and stuff like that is the most common reaction. A very small fraction are actively engaged.
What would you say your goal is in a case as a prosecutor?
Oh, it's always justice. So when we look at a case, a prosecutor looks at, can I prove it? And then should I prove it? That's the first thing is can, and then should I? Because there are certainly cases where equity would suggest that we shouldn't proceed on a case. And we get to apply our judgment at that point. All charging decisions in Klamath County are made by my boss, the elected District Attorney David Scott. He conveys that authority to us as his deputies. So he is constitutionally elected, and then he conveys a portion of his authority to us as his deputies to make that charging decision. I'm not going to call him Mr. Scott anymore. I call him Dave, and I'm going to do that from now on. So Dave gives us that authority, and so for misdemeanors, we have all the deputy DAs in here have that authority. When it relates to felonies, that's where the possible penalty is 1 year or greater. And when we talk about possible penalty, there are also financial penalties associated with these, but the guiding issue is a liberty issue. That is your ability to walk freely in this world. Crimes deprive a person of their liberty. Violations under Oregon law do not. So misdemeanor crimes up to 1 year, felonies over 1 year.
You said we have to ask ourselves, should we charge? What are
Yeah,
some of those
absolutely.
variables that would make you ask, should we charge?
So the fancy word that we use is equity. Is it an equitable decision? And we get to factor in lots of stuff. So we get to, when we have information about possible a mental disease or defect that affects a person, that can affect our charging decision. Whether or not we know that we simply, despite the fact that we are aware of and believe that a crime has occurred, can we prove it? And so if we can't prove that case, remember the first thing is can we prove it? Even though I've got cases in my charging queue where I believe that a crime occurred, I'm incapable of proving it beyond a reasonable doubt, and that's frustrating.
And that's the
Uh,
bar.
yeah. So the standard for our charging under Oregon law is technically, do we have probable cause to believe a crime was committed? But when we are evaluating cases for charging, we're always thinking, if this goes to trial, what do I have to have? And if I don't have all the pieces, I'm unlikely to charge that case.
I wanted to walk through start to finish. So I'm a victim of a crime or I'm a resident and I'm calling 911, right?
Yep.
That's really the start. Um, Take me through that. What happens? Pick up the phone, I call 911. What's next?
Okay. 911 determines who the correct agency is. So it depends on where you're calling from. Your agency gets appointed. So if you're calling within the city limits, you're going to go most likely to the city police department. If you're calling outside of the city limits in our urban growth boundary, odds are you're going to go to the sheriff's office or OSP if you're in some of the more remote areas. So you get dispatched. An officer is dispatched to investigate. So the officer will arrive and they start their investigation at that point. Typically, one of the things they will do, particularly, let's say it's a rural case where someone has been breaking into our house and stealing. I've got cameras up. We only stay there 3 months of the year in the summer, and I'm going to give you real examples. These are all from closed cases, so I can talk about them because they're matters of public record. And I'm also not creative enough to come up with my own examples. So these are real cases. Individuals, they don't live in Oregon full time, but they have cameras up at their property that's in a beautiful remote location because in the past they've had theft. So they put these cameras up, they get an alert on their phone, and they know that there's people on the property. So they call law enforcement. Law enforcement starts rolling in the direction of Polar Bear Lane, and they head off to Polar Bear Lane. And on the way there, they're on the phone with the victim, who's the reporting party. And they say, okay, well, give me the address. How am I going to find the property? What am I going to find when I get there? I want to confirm no one's supposed to be there at the time. Are there any weapons there that we have to be concerned about? So they're gathering information on their way. When they get there, they start their investigation. Now I'm going to change hypotheticals and talk instead. Now let's say the reporting party is at the scene when law enforcement arrives. So they say, I came home and found out that my house had been entered and property taken, burglary. So my house has been burglarized and the police start their investigation. So one of the things they're going to do is first they're going to talk to the reporting party. Did you lock your doors? How did you realize someone had been in the house? What's missing? What's your name and stuff, obviously, because we will need them as witnesses down the road. So they grab what's all the contact information. Any idea who this could possibly be? No, but I have a ring cam. And so they look at the ring cam, and the ring cam shows a blue truck pulling up into the front yard, and you can get a partial plate. So their investigation goes from there. So they work that investigation, and then they submit a report to our office. They believe the report will say, based on my investigation, I believe that it's going to be this person because they come back as that registered vehicle. They live straight down the street. In the report, which we can certainly consider when we're making our charging decision, is that individual has 3 prior cases open like that right now, or has convictions for crimes like that. We know that the person in this blue truck, lots of times you would be surprised at how often our officer like, I know that truck. That's defendant X's truck. He's always in that truck, and this is what he does. Um, Lots of our property cases are solved that way because there are known identifiers from repeat offenders that our officers just from contact, repeat contact, know these people by sight, and just as part of their professional conduct, they know who these people are. So they write us a report, we review it, and then they refer charges. So an officer will say, here are the crimes that I think happened. It's this and this and this and this. And then we, as the attorney, we review it for the final charging decision because as I was saying before, only one person in each county has the authority to make a charging decision. It is the DA for that county. And then through the authority of that DA can be shared to their deputies. So he's empowered us as his deputies to make that decision as well. And that same authority is passed on to deputy DAs in other counties in the state as well. So they have that ability for their own counties.
How much does a criminal investigation, which of course is not your job, right? You
Right.
guys don't actually investigate. How much does an investigation, good, bad, indifferent, impact your part of the process?
The initial investigation, so like I said, prosecution is an iterative process. We can go back and forth, particularly with my caseload and Dave's caseload, Dan's caseload that are more complex. We will work with our detectives to build cases as they go on. There may be times when we have to talk to our officers and say, it would be great if we can get some more information. Why don't you talk to? Why don't you go check? Why don't you canvass? Maybe we issue a subpoena. So that's part of prosecution being a process rather than a result. And so we will go back and forth on that and work with our law enforcement on that. And quite frankly, it's a huge part of it. The quality of the investigation controls the strength of the case.
That's heavy. The quality of the
Yep.
investigation controls the strength of the
Yep.
case. Let's talk about grand jury. I know that you
Yep.
oversee it in Klamath County. I think when people hear grand jury, it feels heavy. How much difference is it of a grand jury indictment versus a verdict by a jury in trial?
So when I say through a charging instrument, I draft an information, and that information is the charging instrument, and it says I believe that the following crimes have been committed, and then I'm going to submit evidence to a grand jury with probable cause that supports those charges. So I say these are the charges that I believe happened. I have probable cause to believe that. And then I provide that to the grand jury. The grand jury's job is to hear the evidence. The rules of evidence do apply before the grand jury, which is why witnesses aren't allowed to make personal statements. They have to just answer the questions from the DA that's doing the direct examination, because it's largely a direct examination. When a witness appears before grand jury, they're asked pointed questions. And that is to avoid contaminating the grand jury, risking that there is a violation of the rules of evidence. And when I talk about the rules of evidence, right now the rules of evidence in Oregon, that's the book, and you can see it's marked up. So there are a lot of rules regarding what can and can't be presented to a jury. For grand jury, the rules of evidence apply, but the standard is evidence otherwise uncontroverted, which means that the grand jury does not consider possible defenses. There will be times when a grand jury absolutely hears cases and they're thinking to themselves, well, that guy's got to be crazy. And that may very well be true, but that is a possible defense. And so they don't consider that when they're determining whether or not there is a sufficient basis to return a true bill for the charges in the charging instrument. Grand jury has a couple of different options. They can return a true bill, which means they accept the charges that were submitted. They can reject that true bill. They can deny it. They can modify it by increasing charges or decreasing charges.
Explain what an arraignment is.
So sometimes people will say it's the first time the defendant appears in court. It's not. The arraignment is the time when they're notified of the formal charges against them. That is not to say that we can't sometimes change the charges down the road, but at that time is when they are most likely to face the charges in front of them. And if we do change the charges, then we have to indict them on any changed charging instrument that we present.
Who comes up with a bail amount, number one? And number two, as a prosecutor, do you see bail as a punishment, as a consequence?
We think of bail as the amount of money you have to pay to not stay in jail. That's incorrect. What you're paying there is security. And security can be anything. Sometimes people post property so that they can get out of jail. Security is some sort of assurance that you're going to come back in the future and you're not going to hurt the community while you're out. It's certainly not a punishment. When you're talking about the amount, who sets the amount, it's not prescribed. There is an unofficial schedule that is used by, I believe, all the judges across the state. Because you got to remember that in general, law requires that we treat any similarly situated individual the same. So two people that are identical have to get exactly the same treatment.
And you're only
And
cash bail, right, in Klamath?
what's that?
Cash bail only in Klamath.
That is correct. That is correct. So a long time ago, the Oregon legislature took away bondsmen. There are no bondsmen in Oregon. The state serves as the actual bail agency receiver for security. So it goes through the state. When you are trying to get a loved one out of jail, if, Uncle Dave gets arrested in the middle of the night for driving under the influence and somehow manages to stay in custody, which we'll talk about later because that doesn't happen anymore. And Uncle Dave stays in custody, but he wants you to come bail him out, and you've got $500. You can go and you take your $500 into the jail. They send it off to the state of Oregon, and at the end of the case, you posting your bail, you may get a portion of that back after fines and fees are taken out of that.
So that was my last question regarding bail is who gets the bail money?
So the first thing that happens is state of Oregon's their money. They get their fine, they get their fees off of the top. Then, so fees come off the top first, then restitution, then fines. If someone posts $1,000 up front, the state takes their processing amount. Let's say they post $1,000 and 4 days later the state dismisses, we dismiss charges against them. They would not get $1,000 back. They get $1,000 less whatever the state's handling fee is. I used to know what it is, but I don't anymore. But then let's say instead they are ultimately convicted of a crime and there is a victim that's due restitution. That is the next priority, is that restitution gets paid. And if there isn't enough posted to pay that restitution, then a judgment is entered for the remainder of the amount.
A beneficiary of bail is the victim of the crime, essentially.
Yes. Yeah. If bail is posted, if security is set and posted, because again, because of some legislative changes, bail's posted far less often than it used to be.
So this leads us into the next part, which is probably what I'm looking most forward to ask you about. And this is referring to what I refer to as the M word, matrix.
Okay.
Tell me.
All right. This resource goes under here, and then I've got stuff up on the screen. So you're talking about the matrix as it relates to the jail. Is that correct?
Yes.
Okay. There are two matrices for the jail. There is a population matrix and there is a Senate Bill 48 matrix. I'm going to talk first about Senate Bill 48. Senate Bill 48 prompted the passage of a presiding judge order, and that order governs all of the counties in Oregon. And that says to every jail out there that if the following circumstances exist, you have to do the following. It takes the discretion away from our local jails as to who they lodge and what security is taking it. It is, I was aware of it, and you and I have talked about this. Part of my job is frustration management. And one of the ways you deal with it is you only learn the bad shit that you have to know. Oh, I just swore. All right.
Okay.
That was the first.
Don't worry about it.
Okay. Yeah, so you only learn the bad stuff that you have to know, and I didn't need to know this until you asked me to look into it. It's very frustrating. There are what happened is the legislature said we've got this horrible, basically criminal justice industry out there, and the whole thing is just to lodge people in jails and prisons. It's an industry, and we want to take actions. And what we're going to do is we're going to identify certain crimes, and if by your strict ORS, your Oregon Revised Statute, the statute number that defines the crime, if you fall under one of these categories, we're talking about category one, then you are released upon your own recognizance with standard conditions. That's category one. So category one, if you fall, if your crime is one on a list, they took every single crime under in Oregon. Well, I'm not sure it's every single one because there are lots of different crimes that are captured in. There are regulatory crimes that aren't captured in the Oregon Revised Statute Criminal Code. I believe that the majority that are captured under the presiding judge order are the in the criminal code. There are other crimes. So, for example, like if you're an industrial polluter and you throw stuff in the water, that doesn't show up in the criminal code. That shows up in a regulatory code, even though it has a criminal consequence to it. It could be a misdemeanor or a felony, depending on how you've done it or who was harmed, but it doesn't fall under the criminal code. So when I'm talking about an ORS, I'm talking about specifically the criminal code. That's our book. This is a majority of what I do.
Mhm.
Um, Although there's a whole nother book that's a little bit bigger than that, that is the vehicle code that deals with, because of my caseload, felonies and vehicular homicides. So when we are talking about Senate Bill 48 release conditions, we have category one. If you fall under any of these crimes that they've delineated in this fashion under category one, you are released with standard conditions. Standard conditions are commit no new crimes, appear at court as required. Oh, man, I'm not going to be able to get all the standard conditions off the top of my head. There's six or eight of
Can't
them.
travel
They're
out of
just
state.
basically it's no, that is not a standard condition.
Oh, it's not.
No. Keep the court informed. So keep the court informed of your address as a standard condition, but not. I'm sorry. I don't know whether or not do not leave the state is a standard condition. I don't know that one.
Okay.
I can look into that if you'd like, but I don't think I'll be able to answer for you today. I mean, I could do it later today, but not during this interview. Okay.
Yeah, I did want to ask though, just real super quick, whether it's standard or whether it becomes a condition, um, during this pretrial stage that you and I are discussing right now, which obviously Matrix can be a part of, there is no monitoring. And that's not just with Klamath though, that is with Oregon in general, correct?
I'm going to just speak on the knowledge that I've had over the past 20 years. There have been times when release has been monitored. In fact, we had a period of time in Klamath County where we had some monitored probation, where we had a pretrial release officer, and you have to check in. And right now, it's not monitored, but it requires checking in. So there used to be pretrial release where you had to check in. But it's not like they put an ankle bracelet on you. You're not subject to GPS tracking or anything like that. We don't, in my career, we have never had that as a condition of pretrial release in Klamath County. I know some counties have had that in the past. And the couple of counties that I was aware of, that was a public-private partnership where they contracted with a private party that did that monitoring portion. And then that private party had like a contact person at the pretrial release office. And so they would say, hey, defendant A is near a school and he's not supposed to be near a school right now. And so then it was actually kind of fascinating technology. Through that ankle monitor, they could call them and say, hey, defendant A, you're not supposed to be by that school. What's going on? And if they don't respond, then they can actually set an alarm off so they can track them. And they have GPS tracking. And the reason I'm aware of this technology is because there was a period of time where we actually used that as our post-conviction conditions for certain sex offenders.
Okay, so we talked about category one with Matrix.
Well, let me give you a really frustrating example of how category one applies. So I went through the list of crimes that are included in that, and that includes possession of a controlled substance, methamphetamine, as a felony. If you're arrested for possession of controlled substance, methamphetamine, as a felony, which means 10 grams or more, then you are released under the presiding judge order with standard conditions. And the standard conditions, an easy way to think about standard conditions are go out, behave, and don't be a criminal. That's what we're telling these people who are released on standard conditions. And make your future court appointment appearances, keep the court informed of your address. Those are the conditions. That's standard conditions.
I wanted to say real quick, you said how it's, it is frustrating. You can understand when people hear that, right? Um, it's not great.
Let me give you a worse example that I have actually experienced, which is a person who, when we talk about our sentencing guidelines, is an A on the grid, which means he has three or more convictions for person felonies. The one that I'm talking about specifically included at least one horrible crime against a child. This person, in addition to those three or more, he had a lot more person felonies. Also had dozens, literally dozens of prior felony convictions and misdemeanor convictions for drug charges. Each time he is arrested on a new felony possession of methamphetamine, he goes up, he gets booked, and he gets sent on his way. Despite the fact that he is extremely dangerous, has proven that over and over again, continues to use controlled substances, and in the past has victimized people in our community as a result of his substance use and abuse. I didn't say it was going to be a happy story.
So when you have to explain that to a victim's family or residents who want to make sure that their families are safe, how do you explain this person got to go home today?
I have unfortunately had to develop the ability to come to terms with the fact that there are things that are out of my control. Um, it sucks because you've met me. I have some control issues. And the reason I'm back at the DA's office now for my third time is because I care about our community. And I want to help and protect it, and I don't have the tools that I need to do that every time.
Because you're in the position as a prosecutor and you see somebody with a background like that, booked and released, one could also say that now he feels emboldened, right? Empowered, no consequences.
Absolutely. That's one of the things that we balance when we're standing in front of the judge and we are arguing to have someone taken into custody and security status. Um, Even if in the best, let's say best case scenario for a case that's subject to Senate Bill 48. So let's say it's a Senate Bill 48 Category 1 case, and I stand up and I make just an extremely compelling argument. I talk about this guy that we were just talking about. I say, Your Honor, you're familiar with him. I'm familiar with him. I've been prosecuting him since I started in the DA's office 20 years ago. You know who he is. You know what he's done. He's got new crimes, continues to not abide by the orders of the court. Let's set bail. And the judge says, you know what? You're right. We're setting security in the amount of. And they set that amount. And the next day, he has committed a new crime. And that's just a frustration that we have to deal with. And part of that comes from Salem. Part of that is when I'm talking about Senate Bill 48, this is an action that has taken the authority away from our local jail. So, category one, released with standard conditions. Category two is released with court-ordered conditions. So those would include things like no contact with the victim, no intoxicants, not enter bars or taverns or a place where the primary purpose of business is the sale of alcohol, not associate with children, or those are all court-ordered conditions, and they generally are fact specific to the case and or the defendant. So sometimes those conditions can be you need to stay in contact with your mental health treatment provider, or you need to stay in contact with your probation officer, because we have to remind these people to do that. So that's category two. And then category three means that the court can set security, keep them in custody.
If a defendant, this is pre-trial, is sitting in jail for several months, would you think that they might be willing to cooperate a little bit more versus doesn't matter, I get to go home, can do what I want? Does it make your job harder when they can just continue to release and release?
Yeah. So let me talk about a couple different things. So when an individual is sitting in custody pre-trial, they have an absolute right to a fast and speedy trial. We have to do that under Oregon law within 60 days. It's called the 60-day rule. Unless the defendant waives it, or unless and until defense suggests that there is a mental disease or defect that requires additional investigation. investigation, in which case the clock tolls on that. So if the defendant waives it, then it can go longer than 60 days. Most people, here's you can take some solace in this. In general, our criminals do not like to sit in jail, so it serves as a deterrent for them. Um, and as a result, I'm going to give you kind of a surprising example. There are people who are very, very familiar with our criminal justice system. They've served time in our jail, they've served time in our prisons. And if they know that the case against them is fairly strong, they will sometimes, I would even say often, quickly resolve their cases so they can get out of our jail and get up to the prison where life is more comfortable. In
Hold
general,
on. Life is more comfortable in
I
prison
knew
than
that was going to, I knew that was going to get a reaction. Yes. So in prison, particularly if you are a relatively low risk offender, when a person is sentenced to a term in the Department of Corrections, the first thing they do is they go to the Oregon State Prison for classification. When they go to classification, it determines where they're going to spend the remainder majority of their sentence. And that's based primarily on the initial crimes of conviction. I think we only have one Measure 11 in prison right now. So if you've committed one of the most violent person crimes that we have, then you're going to end up in that prison. That one, I would assume, is less comfortable. But if you are the lowest category, there is a facility, I think it's in Baker City, where one boundary of the prison is a white line painted on the sidewalk. Um, it is a minimum security prison, and those people there they're out of they are not in their cells unless they want to be. I believe they have individual cells at that location. There are certainly facilities in our prison system where you have individual cells. And they have tons of freedom. There's activities, you have commissary, get to hang out with your buddies. It is not an episode of Oz. So there's TV does a good job of portraying prison violence in a way that my career has not confirmed.
fair enough.
So whereas in our jail, if you are an APOD in our jail, I think you're spending 18-ish or so hours in your cell. You get some time out, depending on your behavior. You have some access to commissary, don't have access to a library. They now have the chirping devices. Have you
Yes,
heard about this?
I did.
Okay.
Yeah.
Which allows them to text and I think call. I know for sure text. They can
Definitely
text
tech. Yeah.
anyone out there. And I think they're allowed to, I think they can stream shit on there too. They can get like
Okay.
videos and stuff.
Yeah.
I've never actually seen one of the devices. I should do that. I'll get a hold of the jail and see what can be done on that.
As I say, I'm glad that you brought up the jail, kind of in relation to our matrix. I can tell you that population, the issues with we just don't have enough room, we just don't have enough beds, keeps coming up again and again. I just want to get a better understanding of there's nothing that the district attorney's office can do when it comes to issues of population with the jail, correct?
Ultimately, the jail has the final say, but they are community partners, and there are times they listen to us. So if there is a particular individual that I there remember I said there's two matrices. There is the Senate bill matrix, and then there's the population matrix. The population matrix is the one where our local jail has discretion. And so what happens is they say, here's the crime you're being lodged on. Here's your criminal history. You do a matrix and you get a score out of that. Based on that score, you're compared to everyone else who's in custody. So if the jail fills up, I believe our facility right now has 155 beds. When we are fully staffed, we can accommodate 155 beds. I believe it's 155. Today's jail population, let me double check, 103 this morning. It was 103 this morning. So we had room for some people physically. I don't know if staffing could accommodate that because there are limitations on staffing. I know that we had, it's a personnel issue. There's constantly people on vacation. When we're fully staffed, if there aren't staffing crises, like we have had staffing crises in the past where pods have shut down and we have lost the physical availability of beds due to staffing. But when the jail is fully functioning, I believe we can accommodate 155. I don't think we're at that right now because there's some issues like we've got a couple new hires that are off at DPSST, the Department of Public Safety and Standards, getting their training and certification to be jailers. Um, but I want to tell you again about Senate Bill 48. If that jail was completely empty and fully staffed to a capacity where we could serve 155 beds, and that same guy with multiple violent felonies and more than a dozen convictions for substance abuse goes in on a new felony PCS meth, he gets out that day, regardless of the capacity of that jail. That's Senate Bill 48. Now let's say instead it is a case where a court has set security and the jail is pretty full. And the judge has said, these 10 people all have security set in these amounts, and the jail only has room for 8. The jail says, eeny meeny, someone's going home. And if I say, hey, look, this particular individual now has 13 cases, there are 3 victims, he continues to have contact. Can we make this one a priority? Our partners up at the jail will say that one's a priority for us as well. We're going to keep them in custody. It means we're going to kick someone else out. Someone still, this is like a busy college bar on a football Saturday. It's one in, one out.
It sounds
And they
like
have
a
to
literal get out of jail free card, actually, is what it sounds like.
not not exactly because there is an assessment made as to who to let out. And it's a holistic assessment. It's looking at everyone and comparing them all together and seeing who the biggest risks are. So, an individual victim is going to feel very strongly about the person who victimized them. But as compared to some of the other people, as a community, that new individual is less of a risk.
Mm.
I know that that doesn't provide a lot of solace to our victims because you're the victims of crimes, but from a greater good standpoint, that's how we have to do that assessment. And we have to do that with limited resources all the time.
So just one more thing, a quick thing about Matrix. Again, with Klamath County, a lot of that has to deal with the lack of capacity in the jail. Is there even a solution for that?
So part of it is a hiring problem, and it's not because it's the same sort of issue that we run into here at the DA's office. There are currently 5 deputy DAs at the DA's office, plus the elected Dave Scott. When I started here in 2004, there were 9 plus the boss. And the boss at that time did not maintain a caseload. Dave maintains a caseload. He has half of the murders. I have the other half. Actually, he has slightly more than me right now. He's got one more than I have right now. We have several, unfortunately. We were talking the other day, and he denies it because he's humble. But I do not believe there's an elected DA in the state that has the same caseload that he has. Um, Normally, like I said, an office this size would typically have 9 deputy DAs. 2 of them would be of my level or higher, with a career prosecutor, 15 years plus of experience, who has tried multiple murders. And the DA would be involved with a caseload to some degree, but largely would be a supervisor, administrative, dealing with community partners. Dave instead serves as his own chief deputy, and I have some of that function. And that's because of budgetary limitations. You've been to Klamath Falls, despite the fact that it is absolutely beautiful. It has a reputation of of having a high crime rate, and it does not offer the same amenities as some of the communities on the I-5 corridor. We don't have a Costco. There are things here that make it less appealing to recruit people here. That includes deputy DAs, that includes jailers, that includes patrol officers. I have on our city PD, I know there are several people that took their first jobs in law enforcement because they wanted to come here and fly fish. That they wanted to come here because they liked living in the high desert and they wanted to live in a remote area, a more remote area. There aren't a lot of people out there. Most young people want to be in places where there are things to do and places to go, and that you don't have to drive an hour to get to a major retailer. And so the challenges that we face in the DA's office in terms of hiring, recruiting, same experienced by our jails. our commissioners have committed to supporting law enforcement. That has not always been the case since I've been in this DA's office. There have been other priorities in the 20 odd years that I've been here. Right now, our current commissioners are extremely supportive of law enforcement. They have made it a priority. Community safety is a priority. And as a result of that, we have seen some increases in wages. We're certainly more competitive here in our office. I know our jail is more competitive and our patrol as well, our sheriff's office patrol. So as a result of that, we are getting more applicants, but we've got to rebuild the stocks of experienced law enforcement that we've lost over the years. We've had a lot of experience retire, and when we did not have the same commitment to community safety, we didn't have competitive wages, and we weren't bringing in the people that would now be ready to move into those more experienced spots. We have this gap in the middle.
I want to take a step back real quick though regarding David Scott to give people a little bit more perspective. When you say something like he has a large caseload, over 200 cases?
My boss, David Scott, as the elected district attorney for Klamath County, currently has 500 open cases. I believe in terms of cases, he has five murders. Unfortunately, in those five murders, there are seven decedents, seven victims in those cases.
That's a lot for one person.
Yeah, so by comparison, Oregon Public Defense Services, they treat, when they weigh a caseload for a defense attorney, a full caseload is four murders in a year. No other cases. Four murder cases. Dave has five, plus 495 other cases.
I can say from my experience with Dave, he's not charging unless he is fully confident that he will win at trial. So that is
And he will win a trial. That's he's a I think I've only seen one better trial attorney than him.
really.
Um, yeah, he is the right combination. So prosecutors tend to be either pretty good and charming or pretty good and anal. He is really good, somewhat charming. That's his weak spot, but extremely anal as well. So he prepares cases as well as anyone I've ever seen. Certainly better than I'm capable of doing. He's just certain personalities lend themselves to that. And he has this fairly sophisticated attention to detail, and he knows how to talk to juries.
That's actually a great segue. I wanted to talk specifically about trial. How much does a trial cost, and how much preparation goes in for you, for Dave, for any of you guys there, to prepare for trial?
Okay, so I can't tell you what any given trial costs. I know that in the past, the last time I did a murder was the last time I had a murder trial, because as you're aware, most cases resolve outside of trial. Last time I had a murder trial actually go, that it was a 5 day trial, and which is fairly short for a murder trial, and I think our best estimate, I just did some rough numbers. I had officers in. I had my lead officer sitting with me the whole time because between the two of us, we know the case fully and completely. Had my lead officer with me the entire time. I had a legal assistant. You've met Travis. He helped with evidence. My best estimate that was probably about $450,000. And that's it over about the expenses that went into about a 30-day period ramping up into the trial. That does not include any of my time that went into that case, the 3 years preceding it.
I did want to touch actually when you talked about the settlement negotiation. In the TV world, we see these shows where it's like the prosecutor goes in and shows the evidence and it's like you're screwed, take a deal or we'll see you. And is it more complicated like that? Is it dramatic? Are these long conversations, short conversations? What's it like?
They vary. So
They
there are
vary.
a couple different there's some variation. So a typical negotiation, when I charge a case at the very beginning, I write an initial offer of negotiation. There are a couple different
Oh, you write it down. This isn't a face-to-face.
no, it's a written offer. I create a written offer I try and do it on every case. Sometimes I miss it, and there are times when it's not appropriate. So, for example, I will know I've charged this person 3 times before. They're currently in our mental health treatment court. I'm not going to waste my time to write an offer on this when I know he's going into mental health treatment. The defense has to do part on their side first to let me know that he's still suitable for that treatment court. So I don't do it up front. But for your ordinary case, I will have an offer written in advance, and I do it where it is generally very close to how I envision that case resolving, just because I'm parsimonious. I don't want to waste a lot of time going back, making changes and stuff. I try and craft my original offer to be fairly close to how I think the case is ultimately going to resolve and should resolve, what I believe is a just result. There are some DAs that have a policy if they do their initial offer is high. This is what your client is really facing under the Oregon sentencing guidelines, plus any enhancements that we filed. This is what your consequence could be. Here's your offer. And then they negotiate down from there to what they think is acceptable. I tend not to do that as often. I don't think that's an efficient use of my time. So then that's the first thing. And then they can counter. The defense can come back and say, hey, can we remove this condition? Or can you reduce the fines? Can I get less jail time? Would you consider rolling 2 of these sentences concurrent instead of consecutive, something like that? And they can negotiate. That's the informal negotiation that goes on all the time. There is a formal process called a judicial settlement conference, and that's where a judge that is not assigned to the case comes in and brings the parties together and tries to get them to resolve that. We do that for our most serious cases.
When I think of settling or plea deals, I think that's one of those examples where I'm not sure a prosecutor is always going to make a victim happy.
Oh, no. The negotiations, no one
Sorry.
ever comes out happy. No, no, no. I mean, there are times, and we consult with victims as to their preferences in the resolution of a case. I'll use an example I resolved recently. I had a juvenile victim where father physically abused him. Parents are estranged. He was doing parenting time with dad. Dad got angry, caused him physical injury. Well, there have been issues with them for a while. He doesn't want to go back to dad. And he also didn't want to have to testify. He was terrified about having to take the stand and testify. So I factor that in when I'm resolving the case. I decide rather than make this little guy take the stand and go through that trauma and have to sit on the stand and say, this is what dad did to me on this date, dad gets a little bit better deal. And that's partially to appease the victim, but also to protect him.
That actually leads to my second question. When a plea deal is made, who actually benefits? Is it the victim? Is it the defendant? Is it the state? Who benefits with a plea deal?
All sides benefit and all sides are harmed. That's just the reality. Benefit from not having to expend those resources and time. So let's say it's a defendant who has 13 disorderly conducts in the community, and we give them a volume discount. Like you plead to 6 of these and you get 30 days in jail. Those cases go away and we don't have to deal with them anymore. They're now on probation and they're going to do some jail time. Those cases are done. When you enter into a plea negotiation, a part of contract law takes place, which means that you are now bound by that agreement. You can't come back later and say, hey, I changed my mind, or this part was done and wrong. You don't get to challenge decisions made by that court. So it is unlikely, unless under very few circumstances, if you've entered into a voluntary plea, your ability to appeal is substantially limited. That's very valuable to us because the reason we settled the case is because it was more efficient than trying the case. Having to have settled it and then try it again later is extremely inefficient. One of the considerations that our court gets to make in how they proceed with their dockets is judicial economy. So it factors into every part of the process. The judges get to consider judicial economy, law enforcement when they get called out to a scene. Oh, hey, it's another disorderly at Veterans Park. Do we respond to that, or do we respond to the fire where someone set a trash can on fire behind the church? We're going to the fire instead of the the 2 people that are fighting in the park. So we have to make these decisions with limited resources all the time, and it's factored into it. In fact, uh, there are statutes that allow the courts to make those calls based on judicial economy. So it goes all the way up to the courts.
How long is it? The actual process in a courtroom itself. Is it months? Is it years?
Again, it varies from case to case. And this loops back to the jail. The jail factors into that. When a person is in custody, their case is resolved much faster because it is not pleasant to be sitting in the Klamath County Jail. You are deprived of freedom when you were in that jail. You don't get to move around a bunch. Yeah, you're going to see some of your friends because they do. We listen to their jail calls. We see their chirps. We know, oh, I'm just hanging out with my homie. We see that stuff. But in general, their freedom is reduced and they don't like doing it. First off, they can't get their drugs. Second off, they can't see their girlfriends. All the things that we like to do when we're not incarcerated, they are being deprived of for the most part. And so it causes cases to resolve faster. When I'm going to talk back to way back when we lost the money for secured rural schools, that is, we refer to as the timber money. We went from a fully functioning 150 pod or 150 bed jail to a single pod. And there were instances where I literally had a case. It was caught on a body cam where the woman, she had been at Walmart. She had loaded up a shopping cart with just short of $1,000 in merchandise, and she was pushing out the side, and loss prevention grabbed her, and the cops got there in time. They took her up to the jail, and she was laughing, and she said, "Go ahead, book me. I'll be back at Walmart before you're done with the paperwork." And that was absolutely, literally what happened. He was still at the jail doing the paperwork when he got a call that she's back at Walmart and she's got another cart. So being in jail, be,
Wait, hold on. Let's take a beat on that because it it is frustrating, Cole, right?
absolutely, and I have
I
to laugh
mean,
about it
it
because the
really,
other option is to cry. That's why a fully staffed jail is critical to our ability to do our job here. It's absolutely critical.
let's talk about the politics. This is something I've learned. This is no secret. Klamath County is a highly conservative county, and
Yep.
yet Oregon is considered a blue state. I've definitely learned that clearly, as we've talked about today, politics and prosecution, I feel like they go hand in hand. So, what is that like when you have to really abide by these rules and laws um, set that perhaps maybe a majority of the residents and community themselves don't agree with?
I'm just going to speak personally for me. Um, you tell me what the rules are, I will follow them. There are parts that I know that are frustrating, but I understand the importance of the U.S. Constitution and the Oregon Constitution. There are, they're the foundation for our society. One of the things that I take very, very seriously are crimes that compromise the integrity of our system. So, tampering with a witness, tampering with physical evidence, contempt, perjury, those are very serious because those undermine the foundation of our system. If you can convince your victim, let's say it's because of the domestic violence dynamic. You guys are still in a relationship. She still loves you. You have children together. You're economically dependent. Who's going to pay the mortgage if you're in jail? Because of those reasons, and you leverage that, uh, and you try and coerce a witness, a victim, to compromise the system. I take that very seriously because our system is where everything else comes from. It's the integrity of that system that lends credence to everything else. We talked about that a little bit when we were talking about the balance that we have to make when we're standing in front of the judge and we're asking for security. If I say, Your Honor, this is the most dangerous person in the county, I want you to set security in this amount, and the judge says, you know what, you're right, and then they do, and then they go off to the jail and they're kicked out right away, that undermines the credibility of the system. And so I try to avoid circumstances where I am going to make an argument and win, and still it has no consequence.
What happens if you're preparing for trial and then all of a sudden an attorney withdraws?
That's the reset button, and that is one of the most frustrating things for victims. That there are a couple different ways an attorney can get off of a case. The first and I don't want to say easiest, the first and most clear-cut way is if there is an ethical basis where, for some reason, the defense attorney is placed in a position where they are going to be required to compromise their commitment to the Oregon rules of professional conduct. Then they simply say to the court, Your Honor, there is an ethical basis. I have to withdraw from this case. And the courts are prohibited from inquiring any further. And the most obvious one of those is you meet with your client on day one and they say, Yeah, I did it. I did it. But here's what I want to do when we go to trial. We're going to say, No, she's a liar and it didn't happen. And this is really what happened. Well, as soon as they said, Yeah, I did it, if you believe them when they said that, you can't ever put them on the stand and have them say, I did it. If you, as a defense attorney, have had a conversation with your client and you believe them when they say, I did it, you can't ever put them on the stand to do that because what you're doing there is you're facilitating their perjury. And you can't knowingly do that. And so if you've had that conversation and then your client insists, because ultimately your client decides whether or not the defendant gets to decide whether or not they testify, they have that absolute right. There are a couple things where a client in a criminal case that they have the absolute authority is. They decide whether or not they will appear before a grand jury. They decide whether or not they will testify. They have some say into the selection of the jurors when you're going through the jury process. Strategy, motions filing, all of that is up to the defense attorney. So as the case goes forward, you can say, Hey, I understand that you want me to call that witness. I'm not going to call that witness. They don't add anything to my case. They confuse the theory that we're going to go forward on. This is the theory we're going to go forward for your defense. The defense attorney gets to create that. A good one will do it in collaboration with their client. But lots of times clients are like, no, no, we want to go a different direction on that. I can get X person to say this is what happened. Well, you can't do that if you know it's true. And so that will get a defense attorney off the case. That's the number one. Sometimes a defendant will try and fire their attorney. Now, these are court-appointed attorneys. In some instances, when we have extra attorneys around, the court will just say, "Fine, we'll get you a new attorney. That's not a problem." But we are in a shortage. We have a shortage of defense attorneys, just like a shortage of prosecutors. And so you don't just get to hop. If you want to pick, if you're not happy with your attorney, feel free to hire one. The courts will routinely say that. But otherwise, the court appoints your attorney. And unless there is an ethical basis to get off the case, in general, our courts no longer let those individual defendants fire their attorneys. It used to be more common. That's the old, there's been a breakdown in the attorney-client relationship. So that's that middle one where there's a breakdown in the attorney-client relationship where uh, I can't work with my attorney anymore. Well, the judge will say, you're going to need to figure out how to do it, or you're going to represent yourself, or you're going to hire your own attorney.
If a defendant, and I've been in court, sometimes they hire their own attorney, right? And they
Yep.
hire a really good one.
Yep.
Um, but when you are a crime victim, you are you're getting the prosecutor of that county
What the
or
hell you mean by that?
a DDA. Well, no, I haven't. I didn't finish. And I've said this several times that Klamath is lucky, in my personal opinion, because of David Scott and frankly yourself. However, it does seem that if a defendant does come from financial means, they get to choose. Do you have any thoughts on that?
So I want to explain a couple things. First off, our local attorneys in town that handle criminal cases are, for the most part, experienced and capable. They're not all equally capable. They're not all equally experienced. Some have strength in certain areas that others don't have. And but if you get a court-appointed attorney in Klamath County, you're probably going to get a very good, capable attorney, better than you could hire if you went outside of our community. And there's a couple reasons for that. It's because first off, the attorneys that practice here, they know me. They know they can call Cole and say, "Ooh, hey, Cole doesn't. Cole is less concerned about cases like this, or he's more interested in having probation on a case like this, or he thinks that community service is going to be a better result for a case like this, or he thinks, or this is a tough case. You've got Cole on this case. This is your best offer. You have to resolve it this way, or you're going to go to prison for a longer period of time." So because they know me, they are in a better position to advise their clients. And that is the case across the board for our defense as it relates to us in our office. They also know our judges and they know our court staff and they know how our courts work. They don't work the same everywhere. I just happened to have an out-of-town attorney resolve a case with me earlier this week, and in some email exchanges, we had some confusion. We realized we were using different vocabulary because the vocabulary changes from their shorthand. Like we talk about mandatories. Mandatory, that's when our courts have individual docketing. So each judge has cases that are assigned specifically to them. That's individual docketing. Most counties do not have that. They have a central docket. And so there is no mandatory. There's just a call. And so our mandatories are when the judges are hearing their cases. That's not a term that's used in other counties. And so we have a shorthand that we use. And so when he and I were talking about this, we were using different terms and realized, oh, hey, we're talking past each other because we're not using the same language. Once we sorted that out, but that doesn't happen with our local attorneys because they speak the same language. So you are in general at an advantage hiring an attorney, an experienced criminal defense attorney from the community where you live. Do not think that going outside for a high-priced attorney is going to serve you better. In general, local attorney is going to serve you better.
Let's go back to jury. Again, in the movie TV world, being on a jury, that process of getting picked to be on a jury, you hear people talk about jury duty. Two things there. How important of a role is it to be a juror during a trial? And for you as a prosecutor, what are you looking for in a juror versus what maybe the defense team is looking for in a juror?
Okay, so we've talked about the grand jury. Now, when we're talking about a trial jury, that's also referred to as a petit jury. And so when we're talking about a trial jury, um, what I'm looking for on an individual juror varies from case to case. If I'm doing a property crime case where the individual has stolen air compressors and generators and copper from farms out in East County, I'm going to want farmers on there. I'm not gonna want the baker from Sherms. I've had the baker from Sherms on a jury before. Was a fantastic juror. I've had a baker. I've had a baker from Sherms on a grand jury before. Fantastic juror. We got a guilty conviction on a child sex abuse case. Uh, but it's gonna depend on the facts who you want. If I have a case involving domestic violence. I'm going to want a blend of males and females. When I'm looking for males, I'm going to want to look for males that I think play a protector role rather than someone who's less of a protector. There's a lot. There are
Sounds
professional
like
accountability,
psychology.
and I suck at it. I mean, I'm actually pretty good at picking a jury, but I suck at psychology. So, um, it, it it's there's a lot that goes into it, and I'm sure that there's stuff that I miss when I do it. Like I said, there are for big law firms, for big trials, there are professional teams that will come in because you can get a jury list ahead of time. So Dave's preparing for a trial that starts tomorrow, got jury list yesterday. He's been going through, they complete questionnaires, and given the nature of the charges that he's trying tomorrow, there's an expansive questionnaire. And with that expansive questionnaire, he's looking at some red flags. So, for example, I'm just going to give an example that's unrelated, but let's say it is a crime involving controlled substances. If I see on that list, do you have any family member who has ever been convicted of a crime? If so, what? And they indicate my brother's been in and out of prison for heroin use. When that person comes in for the voir dire portion, which is the jury selection part where we talk to them, it's called voir dire. Um, and when we're talking to them, I'm going to talk to that person and say, hey, so you mentioned that you had a family member. How has that substance abuse affected you? And there are a couple different reasons I do that. Is because one, I'm going to use that person's own experience to educate the rest of the jurors about the impact of substance abuse, not just on our community, but on that family specifically. And then I'm also going to be doing it to evaluate whether or not he's going to say the state screwed my brother. He never should have gone to prison for this, regardless of what he did. Or, you know what, I'm glad he's getting the help that he needs. So there's a combination. The questionnaires help us point some of our subsequent questioning, and then the questioning can elicit information that provides us more insight on an individual.
But I wanted to ask you, what do you think is the most frustrating thing for you as a prosecutor when it comes to um, Klamath County, the rules you have to follow? What's a misconception, you think?
For the most part, the criminal justice system protects the accused. It is designed to protect the accused. And the more liberal a state, the more that is true, which means that that is very true in the state of Oregon. There are not every state has the same rules of search and seizure. Not every state has, well, just what is a crime differs from state to state. When I moved here from Iowa in 2004, possession of a single joint of marijuana in Iowa was a felony. You would go to prison for that. When I got to Oregon, possession of, I believe at the time, 2 pounds. No, that was after legalization. So, but when I got here, there was medical marijuana, and for the most part, there was a decriminalization of marijuana across the state. So I believe that one joint a cop would just take it and throw it away if they bothered with it. You did not get arrested. You did not go to prison. It did not ruin your life like it did in Iowa. That's just one difference from state to state, and that's because that and it's weird because it's this balance. You know, we live on the eastern side of the Cascades. People moved here a long time ago because they wanted to be free from rules and restraints. So we have a very libertarian, individual, personal rights sort of feel on this side of the mountains, on the Cascades. The rest of the state, extremely liberal, which also believes that there should be a limited role in government intrusion and stuff like that, and more protections for individuals. So those two the liberalism kind of goes around and meets up here in the circle in this political spectrum, and they come together in Oregon to make it difficult to prosecute cases.
The way that it was explained to me, actually, from somebody in Klamath, I thought it was an interesting perspective. He had said, our community, our society has decided it's more of an egregious offense to send an innocent person to jail than it is to watch a guilty individual walk free. And I thought that was very interesting because I gotta tell you, it does.
So that's a fundamental principle of our Constitution. I can't remember who that actual quote is attributed to, but the phrase is better for a hundred guilty men to go free than for a single man to spend a day in jail.
When
That's
David said
it.
that.
Yeah, there's a we'll just say Ben Franklin. It's not Ben Franklin, but he gets credit for everything, so we're gonna say it's Ben Franklin.
Right.
Uh,
But the
but
philosophy is the same. That the argument that's being made there, right, is that they have protections because no one wants to send an innocent person.
Yep, that's exactly correct. And I used to teach classes at KCC in the criminal justice system, and that's one of the things that we talked about is the difference between our system, which was largely modeled on the British system. But when you're advised of your rights under the British system, instead of saying you have a right to remain silent, anything you can and say will be used against you. Instead, the Oregon, or I'm sorry, the British advice of rights is you have a right. Yeah, you have a right to remain silent. However, your silence on this matter could be used against you. That's their actual right. Your failure to suggest a possible defense or explanation can be used against you. That's a fundamentally different perspective than what we have here. Um,
Fair
and
enough.
you asked about my biggest frustration. One of my biggest frustrations is that so routinely people talk about the power of the state, me, my office, my boss, the power of the state to bring a case against someone. When we're talking about people who apply for and are granted a state public defender, a person who they are eligible for indigent defense and they are appointed an attorney, which is the vast majority of criminals in Klamath County, they have access to exactly those same resources. And in fact, to some degree, because our office is funded by the county and not by the state, they are they have access to greater resources. When I was a defense attorney, if I needed an expert to prove a defense, I could get an expert. As a prosecutor, Dave and I are having a discussion. Hey, let's say it's a complex theft case, a complex theft where there's lots and lots of paperwork. Something that's extremely useful is a forensic accountant. I don't have a forensic accountant.
Why would that be helpful?
So I'm a lawyer. I'm not an accountant. I suck at math. And I can read reports and I understand what a narrative will say, but I can't read spreadsheets. I can see, whereas a forensic accountant can say, on this date, the money started here, then it went to this account, and then it went to this account. And then later on, the person who owned this account transferred a portion of it to this account over here. I might be able to do that at some point, but I'm not specialized in it. That's why they're experts. Um, I had a trial. Oh, was it? It was just um, it was 3 trials ago. Defense brought in an expert. What's that dude's name? It's not Stanley. Brought in some expert. He used to long, long time ago, about 30 years ago. He worked for the Oregon State Crime Lab, helped set up the protocols for how we do intox license and stuff now. And for the last 25 odd years, he's been a professional defense expert. Brought him in to the tune of, I think he testified that he wouldn't actually admit to how much he was getting paid, but he did say what his hourly rate was, and I believe it was $250 an hour. And he was there all day for that. Plus, he had reviewed the report. Plus, he got paid for his driving time. And I said, would it be fair to say that you've made over $10,000 on this case? And he said, I don't know exactly, but that would be a fair statement. So he admits that he was getting at least $10,000. Um, I don't have that budget. Um, we have to sometimes decide whether or not to do color printing. Not a joke. That's not a joke.
Yeah.
That's not a joke. I can remember when I was a baby DA, I had a case where it was a failure to perform duties of a driver. A gentleman had backed his car up. He was at a convenience store, and the gas pumps were over here and he was parked here. He backed into a car that was getting gas. And you could see from the video that the car rocked and then he just drove off. And so I had all these still pictures and I'm printing them out to show the damage that the cops had taken and the damage. So the damage on his vehicle, the damage on the victim vehicle that received the hit to show that an ordinary person would know that they ran into that car. And I printed them out and my boss calls, is like, hey, did you print all this stuff out? I'm like, yeah, I got a trial this week. He's like, you're going to need all these? I'm like, well, I don't know if I'm going to need all of them. He's like, well, don't print them out if you don't need them all. Because color
Well,
printing was real expensive.
right. But that goes back to what we talked about before about budgeting and having to make those decisions. What do you don't do in a situation like that on any case where perhaps you feel like getting an expert would be a lot, it would make our case stronger in the courtroom. What do you do? What's the solution? Do you go to the BOC? Like what is
So I've never had Dave tell me no on a case where I said to him it was important. We can make it work. But part of that is he trusts my judgment and he trusts my experience. I'm not gonna bring in some surplusage every time I go to him with something like that. It's because I know it's critical on an important case. And that's because I understand our budget. We've got a brand new guy. We're gonna have to teach that. We're gonna have to teach him that. Because right now he's off at DOJ at baby DA school, and they're saying, "Oh yeah, you'll be able to get this sort of stuff and this sort of stuff." Well, that's fine if you work in Multnomah County or Washington County, where they have lots and lots of resources. That's not the way it is here. So he's going to have to learn how to be thrifty in his prosecution because that's just the reality of working in a small county.
your job is making communities safer and getting justice for crime victims. It's just hard to understand the balance and difference because there definitely is one. It just feels like your guys' job is astronomically a lot harder than the other side.
I've done both, and that's a true statement. Actually, one of the things that we started talking about that I don't think I ever answered fully and completely was how long does a case take? Um, it used to be there will be times when just as a general example, let's say it's a case involving child sex abuse. A fast resolution on a very serious crime involving child sex abuse is going to be 2 years. That is a fast resolution. I'm sorry, 1 year is a fast resolution, two is a typical resolution. Um,
And not from when the crime was committed.
that
From
is from when we charge them until when the case is resolved. So, in a case involving child sex abuse, it is possible that that victim has been living with that crime for 14 years before I get a guilty conviction.
what do you tell a crime victim or a victim's family when they start this process? Do you say, this is going to be a long road?
Yeah, I try. You've had this discussion with our office. I don't want to talk specifically about the case, but you have had me say This is going to suck. It's true. It's true.
It's so true.
And and,
I feel
and
like
I don't feel I tend to be I've never found it advantageous to mislead a victim as to what this process is going to be like. It, now you know what you're going through. Now instead imagine I have someone who I have a victim who has been subject to physical abuse from her spouse for the past decade, and she finally got to the point where she was safe enough to get out of that house, get away, tell a family member, tell someone, and now come to our office about this. And I am telling her that great job. Now for the next 2 years, you're in limbo. That I have to do that. I have to say, here's the process. Here's what's going to happen. And that's without even factoring in we're 10 months in and the attorney is fired or the attorney has to withdraw for ethical purposes and we start over again. And if it's a complicated case where there's lots of documents or where a defense attorney has done some investigation and said, oh, well, they're alleging that a crime occurred on this date. He says he has an alibi witness for that. I have to investigate that. That's going to delay stuff. All the shit that the defense attorneys do on one case, a second attorney is likely to do on that same case over again. Because when I was a defense attorney, like I said, I've got control issues. I have a way I do things. If another attorney didn't follow that, I'm going to redo it. I'm going to start over again and do stuff my way. Any good defense attorney is going to do that. They're not just going to accept what came before.
let's talk about evidence real quick.
Yep.
Um, I had never heard of a motion to suppress. This is the ability to suppress evidence from a jury. If there is evidence out there and you as a prosecutor are like, I really want the jury to see this, and obviously the victim's family wants that too, and let's say it's axed, doesn't that make your job harder? And and would you consider it to still be a fair trial then if evidence is suppressed?
So the issue of suppression comes down to playing by the rules. Um, I'm going to give you an example of stuff that should be suppressed and tell you about how it affects a case. All right. So I told you examples about when we used to be able to do drug interdiction in Oregon. The rules have changed. So when I first started, if an officer got up to they'd stop a vehicle and they would start talking to people like, "Hey, where are you headed today? What's going on?" They're fishing at that point. They've stopped you for a violation, but they're fishing. They're trying to look. There's something suspicious about that vehicle. They're trying to see if they can get something more when they're having that conversation roadside. So during my career, that changed to now you can't ask any questions that are unrelated to the stop unless those occur within the unavoidable lull. So an officer would go up and say, "Hey, where are you headed today? All right, let me get your license and registration." Then they would run them and say, "Hey, all right, can you check license and registration, make sure this guy has insurance?" And while they're waiting for their dispatch to get back to them, they go back to the window and they say, "So, hey, where are you headed today? How long were you down there?" And they're starting to look for an implausible explanation. So, oh yeah, we just went down to Sacramento for the weekend, headed back now. Oh, where are you headed? We're going all the way up to Tacoma. Then the officer back in the day would say, well, I would know based on my training experience that this is a high traffic corridor for drug traffic between Sacramento and Spokane. And the individuals will often use the 97 corridor to avoid the more heavily policed I-5 corridor. And so during that unavoidable lull, they would ask these questions and try and build reasonable suspicion to do more of an investigation, to pull people out of the car and search, to seize a vehicle. That law has changed. That law has changed so that now you can't ask questions unrelated to the nature of the stop unless you can articulate an independent reason for your having done so. So you walk up to the vehicle and, hey, the reason I stopped you is your left tail light's out, license and registration. Also, I noticed you got a syringe there. Are you diabetic? Perfectly okay because you see a syringe and you're making an inquiry as to what could possibly be a syringe used for heroin, methamphetamine, some controlled substance. Or you see a pipe that has a white burnt residue. That's not going to be marijuana. That's not going to be tobacco. That's going to be cocaine, heroin, methamphetamine. So you can inquire about things like that because you have an independent basis for that subsequent investigation. Original basis for the stop was the violation upon contact with them. So that has changed. If instead now I want to talk to you about, because we had this period of transition, law changes where you can't ask these questions. So now we got old school cop comes up to the car. and says, I stopped for your tail light. You got any drugs or guns in the car? That's no longer okay. Used to be absolutely okay. When I started my career, absolutely okay. Phase two, after the unavoidable lull. It was okay during that unavoidable lull. Now, can't ask that unless you have a basis. If you walk up and you see ammunition sitting on the seat, then for an officer safety reason, the officer can say, hey, do you have any guns in the car I need to be worried about? Then it's okay. If that car is completely spotless clean and the person just looks hinky and they have face tattoos and you're looking for a reason to pull them out, you can't do that. And there is absolutely reasonable. So let's say instead he's like, hey, I got him out of the car, search it, and I found a gun under the seat. And there was nothing that really led him to that other than his instincts. That gun goes away. That evidence gets suppressed. And that's one of those things where I say, tell me the rules, I'll follow the rules, and I'll teach my officers to do the same thing.
Have you been in cases where evidence was suppressed and it was frustrating for you?
Oh, hell yeah. I've had to flat out dismiss substantial quantity drug cases where we lose the dope. Yeah. Yeah, it's frustrating. But I mean, also, we've taken that drug off the street. There's a substantial cost to the individual who is trafficking it. Um, yeah, I'm not getting jail. I'm not getting probation. One of the things we didn't talk about from the very beginning is that there are six goals to the criminal justice system. This is part of me going back to my days of teaching criminal justice. But they are general and specific deterrent. A general deterrent is you create a punishment for bad behavior so that everyone is less likely to commit that bad act. That is, you
Not
don't
in your
speed.
state, though.
Well, but look, we do. We have lots of general deterrents. We have speeding tickets. A speeding ticket is a general deterrent. A specific deterrent is when the punishment is designed so that it's designed to make an individual less likely to recommit a crime subsequently. So, look, you just had your driving under the influence, and as a result of that, you had your license suspended, you had to do 2 days in jail, you had to do your victim impact panel, you had to have your ignition interlock device. That was inconvenient for a while, right? Don't do it again. And for the most part, that's going to work for your average uh, impaired driver. So that is a specific deterrent. So we're talking general deterrent, specific deterrent. Then there are the three R's: retribution, restitution, rehabilitation. I'm going to talk about rehabilitation first because Oregon focuses a whole bunch on rehabilitation. Can we make you through this process of punishment less likely to commit crimes in the future? That includes things like alcohol and drug treatments, skills building courses, GEDs, subsequent education, stuff like that. Rehabilitation that's our third one. Restitution is trying to make a victim whole for the harm they suffered. Retribution is flat out punishing you. You did something wrong, here is your punishment. That one is undervalued in Oregon and highly valued by me personally. I believe it's also valued by our community. Here in Klamath County, I believe that retribution is important. We want offenders to be punished for what they've done. And then the last one is real simple. That's incapacitation. You make it so that they're in a position where they can't commit new crimes for a period of time. Jail is an obvious one, and the most obvious one is the death penalty. That's the ultimate form of incapacitation, is that if you impose that one, they're incapable of committing subsequent crimes. But if you put someone in jail for domestic violence, it's unlikely that during the period of time they are in jail or prison that they're going to be able to commit a new crime of domestic violence.
I have to tell you, I completely agree. I have talked to many, many Klamath County residents, and they they want to see criminals. I don't know if punished is the right word, Cole, but that there's consequences.
Held accountable.
Held accountable. Yeah.
There are consequences for your acts. Good and bad, there are consequences. And right now, our system is skewed so that the consequences for bad behavior aren't proportional to the bad act.
Right. And we see that in multiple cases and the stats and things like that. Do you have a solution? Because I'm still looking for one.
So our
It's
judges
voter, right?
have,
How people vote.
let's just talk about an A misdemeanor. Maximum possible penalty for an A misdemeanor is up to 364 days in jail. We have individuals in our community. I have someone that's currently on my caseload because he has been sentenced on, I believe, at least six, it may be nine counts of driving while suspended. He doesn't care when the judge says don't drive. His license is suspended from a prior Dewey and continues to commit new ones. So resolved a bunch of cases because the defense attorney didn't like my offer. They did what's referred to as a plead and argue. They said to the judge, "Hey, Your Honor, he's going to admit he's taking accountability." This is the way they do it. It's like, well, my client really wants to take accountability for what he's done here. He's sorry for having driven the nine times that he did it, even though the judge said him not to do it. Uh, so he really wants to take responsibility for what he did.
Right.
Please just give him 30 days in jail. Well, I stood up and I said, Your Honor, that's not right. And if I don't get to say this to the court, but I'll say it to you. These individuals middle finger the court. They say, fuck you. Your rules don't apply to me. I'm going to drive because it is more convenient. And by the way, this particular individual, the officers, when they stop me, they're like, you know, you're not supposed to drive. What are you doing? It's like, well, how am I supposed to get to the grocery store? Well, I had to get to work. These are not necessity defenses. This isn't, I had to get a sick person to the hospital. I had to get to the store to get medicine for a sick person. These are not necessity. These are matters of convenience where they don't think the rules apply to them. So in that case, I stood up and I said, Your Honor, he's got nine cases. He's pleading guilty to nine cases. Here's what I want you to do. Put him on probation for the next 5 years, sentenced him to 300 days on a combination you again for a violation for a new crime. I want you to sentence him to another 300 days. And for each time after that, another 300 days. And Judge Atkinson actually did that on this case. She said, You're getting 300 days for these first three, and then you're going to be on probation to me for this amount of time afterwards. And if I see you again, you're going to get another, I forget how much she said at that point. And guess what? Two more cases after that. And guess where he is right now? Guess. Go ahead. I want you to guess.
Is he at
He's
home?
not in jail. He is not in jail.
You know,
So the judge did
the
everything
kid
she
uses the
could.
word cringy, Cole. That's the
The
word.
judge did everything she could to hold that person accountable. But because of our capacity problems, because right now our jail has eight people, seven people charged with murder, at least a dozen charged with crimes, sex crimes against children or adults. Easily that number for assault two or assault one offenses, robberies, those are crimes where violence was used in the subsequent commission of other crimes. And so those are the most serious stuff. Plus, people that are doing parole sanctions, people who have engaged in domestic violence charges. But because of those serious violent offenders and because of the limitations of our jail capacity, that individual who middle fingers the court every single day, he's out walking the street. Actually, he's driving. He's driving.
So if you're at the deli and you have a resident come behind you and go, Mr. Chase, this book and release thing is pissing me off. What would you say?
There is currently, I think there's a statewide ballot initiative called the End Catch and Release. I fully support it. But even if we get rid of Senate Bill 48, doesn't change the fact that we still have a population matrix. We have a full jail, not enough jailers to staff it to full capacity. We need more beds. We need more money for public safety.
So it's frustrating for you too.
Yep, absolutely. And I want to point out that that example I gave you was a judge doing everything right. She said, what you've done is unacceptable. Not only do you continue to disobey the laws, but disobey my orders. Um, I'm going to hold you accountable. Here is your sentence. Did everything right. And because of other limitations from it, the truth is just an underinvestment in community safety, that there was no consequence. And not every judge does that.
Does
Um,
that upset the judge when that happens?
can't speak for her. I can tell you how it makes me feel. It pisses me off. And she's human too. I'm guessing that
Right,
at the very least, it's frustrating.
right.
And I think I'm being generous in that assessment.
Well, is there anything that we didn't touch on? I feel like we touched on all of it. I'm so thankful for your time today and to be able to kind of explain a very complicated system that is also invokes, frustrations and different types of emotions. I consider the role that you play in this process, as I've said this plenty of times publicly, I consider you guys a pillar of our society, because you are, because you make the community safer, and you prosecute, and in theory, hopefully bring criminals to justice in a very tight system.
The caseload that I maintain, like I said, for the most part, serious felonies. But because of our current staffing, I have other cases as well. But when I have my traditional caseload, we're talking about very serious felonies. There are real consequences. That it is less frustrating when you get to that end result. When you go to trial and a jury finds him guilty, and you get to say to that girl that they believed her. So, and then they go to prison for a long time, and that's good.
Do you take some of these moments, these cases home with you?
Oh yeah, yeah. Try not to, but it's tough.
Well, thank you so much for your time today. I really appreciate
Thank
it.
you.